Get that going. Awesome. This is great. So I'll just give it one more minute and we'll roll.
Hi, Alexandra. I'm Corey. Where is your office located?
We're in Bryant, so kind of just north of University Village.
Okay.
Where do you work?
In Leshai.
Okay, great.
There's a
It's not
lot
too
of
far.
Edward
You have
Jones
to deal
office.
with the cut. You have to deal with the cut, but it's at the right time of day, not too bad.
Yeah. No, there's a lot of Edward Jones offices around U Village.
Yeah. Yeah. Is that what you
Oh.
do? Is that your firm?
Yeah. Yeah.
Okay, great. Oh, it's nice to meet you.
Nice to meet you also.
All right. So we're going to roll here. So my name is Keith Akata. There are some folks that have joined us that don't even know who I am. You found me online through the invitation. So I'm a loan officer here in Seattle with Fairway Independent Mortgage. And thank you so much for joining us on this estate planning class that I'm super passionate about. So I am going to introduce my co-host here, who is in Allie. Can you see my screen okay?
I sure can. Yeah.
Awesome. So let me take that down. So Allie is an attorney that practices. You can see her resume here, and I'll make sure to post this in the chat. And by the way, we're going to be interactive on the chat, so you can post questions there. I'm going to have some PDFs that I'll upload, but I'll post Allie's online digital resume here. And I actually met Allie through a client who was going through a case, and I was able to provide some assistance, and that was the connection. So, Allie, thank you very much for joining us. And without further ado, I would love to allow you to take us, and educate us here.
Yes, absolutely. Well, my privilege to be able to spend some time with all of you. The fact that you're interested in learning more about estate planning is great. I would love to be a resource kind of going forward if that's at all helpful for you, but I just hope you learn something in this hour that we have set aside that is really, really helpful to you in your life and moving forward with making some good plans for your wealth management. I do believe, I think the title that Keith gave this talk is Wealth and Peace of Mind. I think that's one of the main things that you can do for yourself in terms of getting your estate plan in place, is just not only checking a big item, a to-do item off the list, but also just to give yourself that peace of mind that you've really thought through and talked through what would happen in the event of your passing. Or the passing of a loved one close to you, because sometimes I do help folks who are dealing with the passing of their loved one. Of course, you'll feel such good peace of mind. So I have a prepared kind of estate planning fundamentals I'd like to talk through with you all. Estate planning is one piece of what I do. I'm also a collaborative divorce practitioner, so I see people go through divorce. I help them with their estate planning post-divorce, and I do a little bit of adoption work as well. That's a little bit about me. As far as being a lawyer, I've been a lawyer since 2005. I was a King County prosecutor to start, and then joined this firm where I am now, Holman Cahill, in 2012. And I've been loving the work that I've done here since that time, and have been doing estate planning since that time. So I'm going to go ahead and share my screen and make sure that Keith lets me know that he can see it and all of you can see it. And then I'm hoping to kind of talk through these fundamental points. And then when we have the chance, or even in the middle, I would welcome your questions, especially if they're on what I've just talked about. If they're very specific, about something about, or a friend's case, or, something you're dealing with personally, maybe we set up a separate time to talk about that. Or maybe if there's a little time at the end, I'm willing to take a few questions. And if I think it's beyond the scope of this sort of more informational time, I'll let you know that. But anyway, here we go. And Keith, can you see my first page there then?
Yes, we are good to go.
Okay, great. So that's me. I'm Alexandra. I go by Allie. So if you if you reach out in the future, I'll know that you actually know me if you refer to me as Allie. So you're welcome to do that. Okay, so first and foremost, why on earth do we need to create an estate plan? Why is it so important? You hear people saying you need to have that in place. You know, sometimes, of course, folks pass away and they know that it's coming and they're able to make a plan in a timely manner. Other times we have unexpected passing, and we are always needing to be prepared for that potential outcome. I sort of joke that I am sort of a worst case scenario thinker, and that has served me very well in estate planning, because what I'm always thinking about is that worst possible case scenario. You know, what if it wasn't that your spouse predeceased you as you had always planned, but instead you died together in a tragic accident? What if one of your children predeceases you, but you have grandchildren and you want to consider them in your planning if your child somehow were to predecease you or die at the same time? So we just don't know how to plan for the unexpected. I mean, we need to plan for the unexpected. We don't know what is going to happen. And so we can't always predict, and actually none of us can predict what will happen. And so having a plan in place makes that better. You need to have an orderly and kind of less costly handling of your affairs. People often wonder, well, if I don't have a will, won't it just go to my children? Won't it just go to my husband? Won't it just go to my parents? And that may be correct. We have a statutory scheme that kind of dictates where your wealth will pass. If you do not put it in your will, it will follow the Washington statute for what happens in an intestate scheme. That means dying without a will. The problem there is, what if that's not what you intend? What if you don't want it to go to your siblings if you have no children and your parents are deceased? That's what will happen. You know, and people really don't know what the intestate scheme is, and it's complicated. When I have cases that I'm administering without a will, we have to be very careful to follow that intestate scheme, and it will often be not what you expect. So you don't want to lean on that, and it will cost more to administer your estate if you just leave it to the intestate scheme and say, oh, the court will figure it out some other time, because it means there will be a probate. There will be kind of a discussion about who should administer your estate, who is going to help kind of get your affairs tidied up and handle your estate. Where will your wealth pass? This just ends up costing you more attorney's fees, because someone has to guide you through that, and frankly, just more involvement of the court. The court will need to know and kind of see what is the plan and how will this all go, instead of, if you create a will, we can limit some of that court involvement. And then, you know, like I said, you want to direct your wealth where you want it to go. There are certainly people who decide to give their entire estate charitably. They cannot do that outside of a will. I mean, they can make some direct gifting, and we can talk about that, of other financial accounts or their retirement accounts. But you want to make sure that you have what you desire to happen with your wealth put into place. That's your legacy. So we want to make sure that's communicated. It's so important. And then, of course, finally, we want to minimize any potential estate tax implications, and I'll talk a little bit more about that. You'll miss out on some opportunities to save money for your heirs if you don't do some planning, if you're in a certain wealth category. So very important to know about that. All right. And then, Keith, I'm just noticing that while I'm doing this, I'm not really able to see the chat as well. So will you just let me know if there's a question that seems like it's appropriate to bring up while I'm going?
Absolutely, will do.
Okay. So what is a typical estate plan? People think estate planning, what is that anyway? Okay, well, it is usually a will, a financial durable power of attorney, healthcare power of attorney, and healthcare directive are sort of some minimal key components. The will itself in Washington is often sufficient. So I think we'll talk a little bit more about revocable living trust later in the time, but people often think, do I even need a will? Maybe I just need a trust. I don't know, but the will is a critical piece, and it is often sufficient. We can do trust planning within the will, which I'll describe a little bit further down the road. And the will is what will dictate what happens after you're passing. This is not what happens while you're living. If you're living, but you become incapacitated, disabled, incompetent, as the statute reads, then someone else has to step in and make some decisions for you. You want to be able to direct who that person is, and that is your durable power of attorney. And so I really like to see those done in two separate documents. You know, you hear about general powers of attorney, and I certainly do that for some folks, but I find often the person you want to step in and make financial decisions for you may very well be different from the person who you want to step in and make healthcare decisions for you. And often spouses differ on this decision point. They say, well, of course, I would want my spouse to make the decisions for me if I can't. But if my spouse can't make the decision for me, I don't want my brother-in-law doing it, or I don't want my mother-in-law doing it. I want to be specific about my interests there. So we really want to be sure to have that in place. Also, especially important for single individuals, if you are not married, it is much harder to make sure that that person who you want to act can act for you without proper durable powers of attorney in place. And then your healthcare directive is the final piece that kind of dictates, puts down in writing how you would like to be treated in the passing, in the final passing. So I have a pretty simplistic form, but I also have a lot of resources I can offer for folks wanting to think through that more specifically. I talked a bit about this. You know, what would happen if you didn't have a will? You're going to spend more money, you're going to encounter more problems, and you're going to encounter the court more. So the court has to appoint who is going to administer your estate. They do that when you have a will, but they don't even make any inquiry into it. If you have named who you want to administer your estate in your will, the court will follow that direction. If you don't have a will, then people have to petition, others have to say yes or no, I agree with that person serving or not. And then the court actually appoints that person, sometimes asking them to post a bond, even to say, okay, you need to actually pay money to this, you know, to the court, so that we know you're not going to run off with this person's estate. So we don't want to have any of that. If we have a will, we can avoid that. Personal representative, it's called, the person who is tasked with administering your estate. We can have that person appointed without needing to pay the court any money, without needing to have a lot of oversight of the court. Another thing that can happen is that you end up with an estate. You won't be here. So you know, a lot of people say, well, I won't be here, I don't want to worry about what's going to happen if I'm not here. But wouldn't that cause you so much consternation if you have a family member who you are no longer close with, and then somehow, because of the intestate scheme, they end up inheriting a lot of wealth? That just doesn't sit right in the now. You know, it's not something, of course, you'll know after your passing, but it's something that I think just doesn't sit right with folks. How about if you have minor children? It's just an absolute essential that you have a will in place to determine a guardian for your children. The event you and your spouse die simultaneously, and there is not a guardian for your minor children. If you haven't thought through that piece, the court will come in and decide who will be guardian for your children. And that doesn't mean they're going to appoint someone you don't know. Of course, they would make a reasonable inquiry into the folks who, you know, who say, oh, I would like to serve as guardian here, but you want to make a much more directed plan for your children. It's absolutely essential. I actually find that's one of the main things that keep folks from doing their estate plan when they're younger or they have young children, is that they couldn't agree with their spouse about a guardian. And I always say, hey, come in, let's talk about it together. Let's workshop who we think may be good, and we're going to put something down, because trust me, putting something down is better than putting nothing down, because if we don't have some direction, then it's just going to be a much harder inquiry for the court and others who love you and your children to determine how to have them raised if you are not here. And finally, go ahead.
Well, Ali, I wanted to throw in there just kind of teeing off as an example for everyone. I have a case, or excuse me, I shouldn't say case. I have a past client who, unfortunately, earlier in the year, both passed away, and they didn't have the will in place. And my involvement was just, they asked everyone that was a professional that assisted the family to be involved. And what was interesting about it, what I learned on the case, is that the appointed parent or grandparents that were going to help take care of the children there's a huge conflict arising because now both grandparents on both husband and wife side are fighting for custody. So
Exactly.
it's something that just want to give a real life example there.
Yeah, and just how horrible for those children to, in addition to losing both their parents, which is just, you know, such a huge tragedy. In addition to that, knowing that their extended family isn't even able to get, you know, together and come to agreement on who would raise them. If you put something in writing and then talk to your family about it, it's so much more, so much better received by your family. They can say, okay, I understand why you would have chosen, you know, your mother versus my mother, and or me, your mother-in-law, and I understand that, and I respect that, and I'm still going to be here. Most often we have and hope that family will still come alongside regardless of who is named in the will. And without a will, like I said, the court has a lot more oversight. So before acting, before selling the house, before making big financial moves, you have to get court approval, and that can be expensive because an attorney is involved in petitioning the court to allow the administrator to take that action. So you've heard me talk about probate a little bit, and what is probate? And I think I said to Keith earlier, my favorite thing that I see on intake questionnaires for new clients is I ask them to sort of think through their estate planning goals, and there are some things that you can check. I think you all will receive the questionnaire if you're interested after our talk today, but people inevitably mark on there avoid probate. And I say, oh, okay, tell me what it is about probate that you want to avoid. And they just say, oh, I don't know. I had just heard that you want to avoid it, and it sounds really scary, and I don't want to have anything to do with it. And so occasionally people have had a bad probate experience. They say, oh, it was very costly. Oh, it took forever. Oh, it took this or this. But by and large in Washington state, probate is not overly complex. It is not overly expensive, and it's actually quite efficient. So probate is really just the process of the court admitting your will, appointing who you have said you would like to do the administering of your estate, and then kind of winding up the affairs of the decedent. It usually takes 4 to 6 months. Of course, there are probates that go on longer than that, but if you have an organized estate plan, then I think it would be closer. It would be closer to 4 to 6 months versus a year. And when they last for a long time, probates, it's often not because there's a big conflict, or, you know, oh, it's just taking forever to sell the house. That's actually usually not what it is. It's just that, you know, it is a big job for someone to step in and do. And sometimes there's just a natural lag. Like, I would like to sell a property on the Hood Canal, but winter is not a good time to do it. So we're going to wait and list it in the spring. Okay. Probate just remains open while we're waiting for the house to sell. That doesn't cost you anything more for the probate to be open. It just means that it's not going to be fully closed within that, 6-month period. And I talk with people all about that. What is involved in a probate? You file the will, you inventory the assets, you need to pay any creditors of the estate, you need to file an income tax return, both the decedent's final income tax return and an estate tax return. And then you need to distribute assets to the appropriate beneficiaries. In Washington, with a will, the personal representative can do all of those things I just mentioned without court intervention. So that just means, we have to have some key language in the will. We have to make sure we get that PR, we call them our personal representative, appointed. But after that appointment, a lot of this just depends on how long it takes the individual, with the support of an attorney usually, to get the job done. And that can vary because, of course, assets vary. How to marshal the assets. Do you want to sell some things off? Do you want to keep a property? These are all big questions, and we can certainly assist. But ultimately, it comes down to what is that serving personal representative want to do. So who's a good candidate to be a personal representative? The other word you hear all the time for this job is executor. It's just a more commonly known word, executor. I find everyone seems to think executor. In our statute, this job is just tasked as the personal representative in your will. If you don't have a will, that person is called an administrator, but same difference. These are all the same job. This person does actually themselves not need to have specialized financial or legal knowledge. They can simply be a good friend. I like to say an ideal personal representative is someone who thinks well and can execute a list of items to do in a crisis. If you're going to have a person who's just beside themselves with grief and can't function, they probably wouldn't be an ideal personal representative. They need to allow themselves and know where their strengths are, allow themselves to grieve, know their strengths are. And I have that sometimes even with spouses where they say, I do not think my surviving spouse will be able to do it. Not that they can't, just that it will be too overwhelming for them. So who could we appoint? So certainly family, friends, family members, family, friends, spouses, these are all good candidates. If you're older, your children are often good candidates, of course. And they, depending on their ages and stages of life, and can they handle that if they were, when they lose their parent, can they rise to the occasion and complete some of these jobs? The personal representative definitely works closely with an attorney in most cases, but they can often work on their own, like I said, and I just give a lot of guidance and then let the personal representative really just let me know what kind of support I can help with and provide. Also, you can allow this person to be paid compensation out of your estate. You can also say that you don't want them to be compensated, but I think that's usually helpful. I think sometimes people think, well, I want my friend to do this, but I don't want to burden her, or she doesn't make enough money to really be able to do this. I don't know that it would be a good use of her time. Well, if you're able to pay her reasonable compensation for her efforts and time, then great, it works. And probably most people take it as an honor. It is a task, but it's usually an honor to carry out your friend's legacy. So, usually that is something that people are glad to do. Okay, so another major role kind of in your will planning is a guardian if you have minor children. If you have children who are grown, you do not need to name a guardian for their benefit, but if you do, if they are minor children, it's incredibly important. This is why I say I think it really holds people back from getting their will in place, but I think I'm a really good sounding board for thinking about who would be a good candidate. Someone who's socially, emotionally, spiritually, geographically, financially aligned with you and your family. I tell people all the time, they think they have to name their sibling or a family member, parent. That's really not the case. You can absolutely name family friends as guardians, and oftentimes they might make a better fit. They may be more aligned with how you parent. And you can imagine what they're like as parents. They have kids the same age as your kids. You can actually know what it would be like to grow up in their household. And that sometimes can be really, really good to think about. And so sometimes it's just helpful to know and invite people to consider, friends over family can sometimes be a good choice. Another reason why you absolutely need to have a will for minor children when you have minor children is that you cannot pass your money directly to your kids in your will. And this is true of your other financial assets or retirement-based assets. They can't go directly to minor children who survive you because we have a law in place that prevents that. So you'd end up spending a lot more money in court to get that money. It's not that it won't ever go to them. It's just that we have to go through many more steps to make sure that we are complying with the law. And instead, what we do in your will is we create a fairly simple family trust that just says if both parents are not here, we need to create a trust for the family, for the children, that will be used for their health, their wealth, or their health maintenance, support, and education over their lifetimes and during their ages of minority. And then we talk through kind of what are some good ages at which point the children would have complete control over those funds or that trust would end. So you need to think through what are the major life events you would want to distribute for? Are there certain ages? I often say like a third at age 30 or a third at age 25, a third at age 30, a third at 35. Just allowing your kids to make sure that they have some oversight so that there isn't any squandering of the wealth. And so there's the trustee. That's the third major role that we have to fill in the trust, in your will, is who will serve as trustee. Serving as that kind of long-term parent for financial health of your kids. And so oftentimes that's different from the guardian, is my input, because the guardian is busy with the day-to-day parenting. The guardian is who is making the school lunches, making sure the violin is packed with the backpack and going out the door, making sure that all the summer camp signups are happening. But the trustee is looking over, usually on an annual basis, something like this. How does the guardian have everything the guardian needs for the kids' support? And beyond that, private school, can we afford it? Beyond that, college, what is set aside? Beyond that, first, new job, capital, putting down a down payment or buying some business equipment for a new business venture. These are something you want someone to be overseeing for your kids. And so having a trustee in place is a good idea. Any questions on that before I move forward? I was going to talk through who would be a good trustee candidate. No, okay, very good. So a trustee, I think, I sort of joke that accountants make the best trustees, but really you just want someone who is fiscally conservative, but who knows your kids and really would want the best for them, who wouldn't unreasonably withhold something. They actually can't do that. They have a fiduciary duty to your kids to manage the trust for the kids' benefit. And so they can't just say no, no, no all the time. They have to say yes sometimes. But someone probably comes to mind when I describe that role. Who is that sort of, again, fiscally conservative person who would be able to kind of rise to the occasion and make those big decisions. So, we've been talking about trustee in relation to your kids or a family trust, but a trustee is also someone who would act if you end up making what's called a revocable living trust and moving all of your assets into that trust now to be administered and managed during your lifetime in trust. And we'll talk about that in a bit, but the trustee would then sort of take over from you. When you create a revocable living trust, you really are the trustee of your own trust. But then at some point, a successor trustee comes along to help manage your affairs for you. And so oftentimes with older couples or individuals, that becomes their children. So then the children naturally rise up and they end up serving as trustee for their parents' estate. That means they can help invest the trust assets. They can make distributions that are consistent with the trust terms. There can be co-trustees. Two people can act together. I don't often recommend it only because it's administratively a little bit more difficult. Two signatures are required, by any institution dealing with the trustees. And that can be a little difficult, but sometimes that's what makes folks feel good is no, not my son alone, not my daughter alone serving, but together, I think they could do it. And I really want to name them as co-trustees. Okay, that is fine. And of course, there's this important idea of independent fiduciaries. So oftentimes, and actually it's surprising to me, but there are plenty of people who come into my office who really just don't have people close to them to serve. They, for whatever reason, haven't created the kinds of relationships. Maybe they're newer to the area. Maybe they just haven't fostered those kinds of relationships where lots of people come to mind for them who would serve in these roles. And that doesn't mean that you're all lost, and you can't determine what to do with your estate or name someone. There are wonderful organizations and companies that can do this work as a professional fiduciary. So either to step in and serve as personal representative or trustee, sometimes even as durable power of attorney, depending on the circumstances. So I have some good connections in those fields. It's a pretty overrun. It's a very busy line of work right now for professional fiduciaries. I think they are pretty overwhelmed. And again, I think it is just because there are a number of people who either don't have the support network around them of folks that could serve, or don't think that support network around them is very effective or efficient with money, isn't going to rise to the occasion and be able to serve. So I think that is a growing area and will continue to be. And so that's an option as well, to name an independent fiduciary. Okay, so Tax planning, again, I always like to say whenever I'm talking about taxes, I'm not an accountant, but this is a broad strokes view of kind of things to be considering with your estate plan. So in Washington state, if you as an individual have an estate that is valued less than actually $2.193 million, this would include any life insurance proceeds. At the time of your death, you will most likely not owe any estate taxes to the state of Washington. This is not the same for federal. So federal has its own limit. And for federally speaking, you can, it's over 12 million now. It went way up under the Trump administration, and we expect it to come back down. So federal estate taxes is still something to keep in mind. I think if you have an estate valued at, 5 or 6 million, you want to be planning federally. So you need to talk to your attorney about the best way to do that. And I usually just hear from folks about the nature of their asset picture. Do they expect to need to be spending down? Like they've been working, and now due to all that work, they're going to be able to retire and they will be spending down their estate in the latter part of their lifetimes, or they expect their estate to continue to grow and increase. And we plan for that. And we discuss how to work that into your estate plan. There are a lot of options available, and most often for married couples, we want to work in what's called a credit shelter trust, where we can make sure that between the spouses, they're protecting up to the full 2.2 million each. So really between them 4.4 million, and we have to work in some trust planning to do that within the will. But all of this kind of trust work that we're talking about here, either a credit shelter trust, a marital trust, a disclaimer trust, these are all this idea of making sure that you shield the maximum from any estate tax liability. These can all be done within a will, and I think people think, oh, I need a trust now. Well, no, these are what are called testamentary trusts. These are not created until your death, and they can all be created in your will. They do not need to be in a trust now. Yeah, and kind of big picture view, it's not that you're not gifting to your spouse, but that you're doing it in a specific way so that you can minimize the impacts of estate tax to your kids. Estate taxes are not paid by the spouse of the decedent. You're not going to feel this as a married couple when the first spouse dies, but your children and anyone you leave your estate to, your estate will pay those estate taxes. So it's just a matter of how much that is an important goal for you, is to limit your estate tax liability. There are plenty of people who come in and say, I don't really have that concern. I don't feel the need to work in a lot of tax planning to my will, and that's perfectly fine. I'll just educate you on what that is so that you know before you move forward, but it's important to consider at least before you make a decision. And I always say, not only do you take input from your attorney, but also your CPA. When I'm working on estate administrations, it's critical to have the input of the CPA because they view it with a tax lens that I do not have. And so I like to get their input on what they would suggest and do in terms of trust funding at the first spouse's death. So we would talk through this decision down the road. But I can do that in real time as well. So if you don't know and you'd want me, or you can always put your attorney and CPA in contact with one another so that they're both understanding your goals. Okay, well, and you often hear about Washington being a community property state, and I think it's just helpful to spend a minute thinking about what does that mean really, and what is the character of property? How does that factor into your estate plan? So Washington is a community property state. That means, broadly speaking, that all property that you acquire during a marriage and all income that's produced from that is community, is shared equally between the spouses. So if you haven't made an agreement to the contrary, such as a pre or postnuptial agreement, then each spouse has an undivided half interest in the community property. At the first death, for instance, we would say. So as I'm sitting and planning with a couple and they have $2 million between them, their house, their retirement assets, whatever, I say, okay, so really you're each planning on it. Your estates are each about $1 million. You each have an undivided half interest in that 2 million. So when we're talking about what's going to happen when the first spouse passes, we're talking mostly about what's going to happen with the decedent spouse's 1 million. And so we have to determine, if we have a lot of assets, which of the assets are we going to include and decide are part of the decedent's assets and which are part of the survivor's assets. And on the planning that we usually do, we don't have to decide that now. We can decide it when the first spouse passes. But that broad view picture is helpful to have, I think, just about community property. What is separate property? That is property you acquire before marriage and growth and income therefrom. If you don't have a separate agreement about it being separate property, if you haven't written that down somewhere, then usually it's just going to be presumed that it's community property and it will be divided accordingly in the estate planning work. I wear my family law hat. I do collaborative divorce work, like I said. So I have a family law hat I can put on from time to time and help folks if they have more specific inquiries about that. It can be complicated in the realm of family law. In the realm of estate planning, it's only important if you're making a different distribution of your separate property for some reason, perhaps a second marriage, kids from a prior marriage, you're making a plan that you want to provide for those kids differently than your kids from the second marriage, something like this. We often will incorporate separate property considerations there and what to do. If you don't know what it is, it's likely community property, and this all can get complicated very quickly. So it's helpful to just have a very, a very organized overview of your net worth picture is just something I advise for everyone to do. Annually is a good time to do it, just for yourself, if nothing else. I ask clients to bring it in when we meet. I don't need to see, statements or anything. I just want to have a broad strokes view of each of your accounts, the nature of them, a rough estimate of what they are worth, so that we can make appropriate plans for each type of asset. Usually your will or trust will consider your estate as a whole. It will not call out specific items. It will not usually say the house located at 123 Street goes to my daughter. It will usually keep it more broadly defined, because we want to allow flexibility for changes in your life circumstance, for sale of that home. But we have other ways, and especially when you're in kind of what I call that third phase of estate planning. First phase is young single person or young marrieds with children. Second phase is when your kids are kind of growing up, launching kind of that high school, college time frame, because you're really making some big financial decisions in there around supporting them and all that. And so that's another good time to think through your estate planning, when your kids have launched or are launching. And then retirement. And that third phase, retirement, can include so many different phases. And of course, I'm able to help there, but a lot of my clients are in that retirement phase planning. And in that retirement sort of third phase of planning, you're thinking more specifically about the type of asset and how you want to hand it down. And so we can make more specific plans within the estate plan. Okay. Okay, good. This is a good segue to what are non-probate assets. So on that list of the spreadsheet I was saying of like your assets and debts, non-probate assets are things that can pass outside of probate. That's what it means. They still count against your estate tax limits that we talked through earlier, but they can pass directly. They don't have to go through probate. So your 401k, 403b, IRA, your retirement-based assets do not need to flow through or go through probate, as we say. So a big reminder is that you need to make sure your beneficiary designation forms on these assets are up to date, are what you would want. If they are going to minor children, we may want to consider them flowing through the trust that you've created for your kids to give your trustee more flexibility, but they don't have to. Your kids just won't be able to access them until they're much older, until they're 21. And so you want to be thoughtful about that and consider, okay, what do we want to put in as our beneficiary designation here? Do we want to flow through the trust or not? But thoughtful planning, especially in that retirement phase, allows you to do things like make a charitable gift with your IRA directly to the organization you care most about. And that's such a beautiful way to gift and it's something that folks are doing more and more now. So there are a lot of different ways we can think through kind of your specific asset picture, depending on the phase of planning you're at and how important that is to you. But we don't have to get as granular if we don't need to, and if you don't prefer to, but that's what non-probate assets are. So overall, Washington, I always say this is a good state to live and die in. It's a relatively streamlined probate process. We don't need to go to extremes to avoid probate here. I think a way to think about it is that if you lived in another state, New York, Texas, California, you're going to have, they've adopted something called the Uniform Probate Code, and they're going to include in their, they're going to tell you, absolutely, you have to avoid probate. And here's why, because in our state, the attorney who handles your estate, thanks to the probate code, is going to receive a percentage of the total estate. That percentage could be like, it's up to 10. I think one of them is 10. And people just, of course, are like, no way do I want my estate planning attorney to receive that part. I'm always like, why don't I practice in those states? But just kidding. I think that's not what you want your wealth to pay. That's not the purpose of this. So in other states, folks will say you need to make sure you avoid probate. We don't have anything like that in the state of Washington. And paid on an hourly basis, and there's absolutely no percentage gift to the attorney out of the estate. That's I think a little crazy, but they get folks to then create a revocable living trust now to make sure that they avoid probate, but we don't have that here. So a lot of times I'll have folks who've moved from another state and they had a revocable living trust set up in that state for their assets, and I can absolutely work with that, and then we can decide, do we want to continue to have that trust go on, or do we want to revoke it and do something different? But often the bigger problem I run into is people never fund that trust. So they go to extremes to create a revocable living trust now. And this is a lot of information. So if you've lost me, I can circle back and make sure you understand. But if you have a revocable living trust, you actually have to fund it. You have to move your house into it. You have to put the accounts that you want to avoid probate into the trust so that you make sure that they're able to just go right through the trust and don't need to go through probate. So, like I said, here in Washington, we don't need to do all of that because we have a good system. We have non-intervention in place. It is a very efficient program. It is very state specific estate planning. So I don't know if the folks on this call are joining from other states, Keith, but it's important to know.
Mostly in Washington, looks like.
Yeah, so this is great for all of you, but for your friends and family and for others in other states, it really is important to do state-specific estate planning work. It's not that your will won't hold up or what you've put in your will won't be followed, but you may have things that would be handled differently in another state. So I always tell people, just take your will that you've executed here in Washington with you when you move, of course, and then make sure you meet with an estate planning attorney in the state you move to make sure that it meets that state's expectations and needs. I can't remember if I have a specific slide about revocable living trust, but I'll just speak about it. I'll go back and speak about it here for one more moment. Sometimes financial planners or folks who have heard from their friends they need a revocable living trust, I absolutely will do that work for folks. I'm not saying I won't. It is more expensive. It does take a little bit longer, and we just make an individual inquiry for the client if that makes sense for them. There are often factors that would push me and the client towards a recommendation of either keeping their revocable living trust and amending it, and or creating a revocable living trust in the first place. And those are too detailed for this seminar, but we can talk through if that makes sense for you. And when you do a revocable living trust, you still have a very basic will that goes along with that makes sure that all of your property does ultimately go to the trust even after your passing. So there's still what's called a pour over will involved if you do a revocable living trust as part of your planning. Okay, so that is mostly your kind of the will. We've been talking a lot about the will and the scheme, you know, what happens with your will and all those various pieces. Now I'm going to talk about some of the pieces that we touch on the very beginning. You are alive, but you are incompetent, disabled, not able to make decisions. So who do you need to appoint to do that? And everyone needs these in place. Your financial durable power of attorney. So this person is called an attorney in fact, or a person who stands in your shoes on your behalf to act upon your incapacity. So if somebody is undergoing, you know, is in an accident, for instance, is undergoing surgery at Harborview, and you know, if someone needs to get in and move money to pay a bill or pay the mortgage, or you know, pay for some other additional medical care, this is the person who would be doing that financial work. They would be the one who would be saying, okay, great, I have access to these accounts. You don't have to have this person be named to act immediately. So most of my durable powers of attorney are what are called springing up powers. They only spring up and act when you are disabled or incompetent. However, if you are older and you don't have a lot of oversight in your life anymore, and you want your kids or your loved ones to start helping you make those decisions, then I talk to people about immediately active durable powers of attorney, so that kids can do more, spouses can do more for spouses later in life without needing a whole bunch of signatures. They can just use this form. You know, the tasks and jobs that a financial durable power of attorney can do for you range from, you know, accessing your safety deposit box, to filing a tax return, to reinvesting your assets. I mean, it's a big job. And so you don't want to immediately appoint someone without some thoughtful consideration. Okay, let's say you didn't have a financial durable power of attorney, and you didn't have someone alongside you, and your kids didn't have the power to act. You may have to have what's called conservatorship started, where, you know, you've heard about these, of course, in the news, but where someone has to help oversee your money and how it gets used for your benefit. So we don't want that. You know, that's just completely unnecessary and expensive. Your healthcare power of attorney is your healthcare person who steps into your shoes and often is a trusted friend or family member who would make medical decisions on your behalf. You know, nurse friends make great, I think people who are in the medical field make great healthcare powers of attorney. You know, it's a different skill set than a financial power of attorney. If your children are, if you're an older person and you're thinking about naming your kids, but they aren't very medically in tune, or they don't make medical decisions very well, they become overwhelmed or nervous, and you imagine that would be the case, well, why not name a doctor friend, or you know, if one, maybe even someone in your community that knows and cares a lot about you and your health needs for whatever reason. You're in the same support group, or, you know, there could be anybody. You don't have to name the people closest to you. Often that is, of course, what happens, but I think it's important to think about who would really think about your healthcare the same way you do. And so something to think about. They are legally bound to make decisions as if they are you. So they need to look at your stated directive, and that's the next piece, which is also called your living will. And that's where you're going to state your express desires for how to be treated regarding medical treatment when you are terminally ill or permanently unconscious. So I kind of said earlier, I do a fairly basic healthcare directive for people who, you know, if you're in good health and you are, you know, not facing a medical crisis of any kind, it is absolutely sufficient, so that your healthcare decision maker knows how you feel about how you want to be treated at the end of life. But for folks who are, you know, suffering from more long-term diseases and things that are impacting their ability to function, there are more options, and there is a lot more detail that can go into a directive. And actually, there's a really wonderful organization called End of Life Washington that offers free resources online for folks with respect to healthcare directives. And I think it's a really wonderful resource. So often I will work with clients on that and just have them start looking over some of those things. They have dementia related or dementia focused healthcare directives, et cetera.
Hey, Ali, I wanted to
Yeah.
just add there, or my parents had I would say the first round of the healthcare directive and the power of attorney. However, they never revisited it. And part their fault, part the attorney that I ended up finding that didn't check in.
Yeah.
They never updated it. So where this is, I just wanted to stress everyone to know is in Washington, and I don't know if this is all, but through my experience, when my father was terminal and he had colon cancer, um, the there came a moment where antibiotics was considered prolonging life, and because the do not resuscitate or healthcare directive was very vague, he says, "Well, Keith, we have to ask. You know, that could be against his wishes. So,
Mhm.
do you want to continue with it because he is terminal?" And then I asked, "Well, what does that mean?" He says, "Well, if we stop giving it to him, you're only going to have a very short amount of time, within less than a day, to be able to talk to him, and he won't be able to interact anymore because we'll put him on heavier medication like morphine." And the challenging part, just to help everyone understand why this is so important, is because that moment decision, once the doctor was there, he couldn't leave my side. I literally was in shock. I was like, I have to make this decision right now." And he goes, "Yes." He goes, "I can go down and see another patient down the hall. And when I come back, you have to tell us what you want to do." So
Mhm.
it's tough because you're making a decision for a loved one
Mhm.
and you're totally unprepared. Right. So I just want to express how important it is to have this in place, and it's nobody wants to think about end of life, but I I know for myself, just using an example, I would not want my oldest daughter to be making a decision because she is the most fragile in our family. So, it's that forward thinking process of where, it's just exercising based on how you wish things would go instead of leaving it up to them to make those decisions.
Yeah. And there's both comfort in that you do have such a voice, right? That the doctor said, well, Keith, this is what the paper says, but what do you want to do here? Right. There's comfort in that because they're going to
Mhm.
listen to your healthcare. The providers, trust me, are going to listen to your healthcare decision maker. They are going to ask you, what do you think the person would want? But if you have put some thought into the detail of that, sometimes that can be much more appropriate. And when you have a terminal diagnosis, for clients of mine who've just had horrible circumstances, they have sometimes time to do that. You can make a plan that includes more, as you move into hospice and et cetera, you can make a plan, but at a minimum, put some thought into this for your kids or whoever you choose to act. And it is important to know who would not be well suited and, make sure you don't have to give that burden to them. Um, Okay. Oh, I did have one. I couldn't remember if I had the slide on revocable living trust. So it is a will substitute, meaning I mentioned you would have a little mini will along with your revocable living trust that essentially says, it's called a pour over will actually. And it essentially says everything I forgot to put into that revocable living trust, I want to put into it. So when I have the clients who've moved here from say New York and say, oh, I did all my planning, I have a revocable living trust, I'm good to go. And then I ask them, what did you put in the trust? Like, where is your schedule of assets that are held in the trust? They say, what? I didn't do that part. And then I say, well, then you have kind of a pointless plan because we're going to end up probating your entire estate anyway, using the will to then make sure that everything you have pours over into the trust and then is administered. But then you're paying two costs because now you've got both the probate cost and the trust administration cost. I mean, of course, they link up and work together, but I just think if you're going to create a revocable living trust, part of my job is to talk with you about how to get it funded. So making sure that clients know, okay, we're going to go ahead and deed your house into the revocable living trust once it's created. You really need to think about it that you don't own, you, Keith Akata, do not own anything. Your trust owns everything. So when you go out and buy a new house, you're not a new car, you're thinking, I should do this in the trust. If I really want to limit the amount of things any administrator of a trust would have to do to deal with, I need to make sure that I actually buy this in the name of the trust. And so that what you're trying to accomplish is at your death, you really don't own any property, but it's all owned by the trust. Then the trust terms really determine what will happen to all the trust property. And that's where I talked about earlier, you may name a successor trustee, you will name a successor trustee, usually a child, an adult child who is responsible to manage that for you. Also can be a friend. There's no tax benefit to doing a revocable living trust. I think people really think that, but we use the same tax planning strategies and wills as we do in revocable living trusts. So that is important to know. I just like to remind people about charitable giving. We work it in. We can work it in at any phase of your estate planning. And many of my clients just say, "Hey, I'm a giver during my lifetime. I want to do a lot of my giving so that I see the benefit of the gifts I make." And I say, that's wonderful. In that case, if you don't need to do any planning in your will, that is fine. You can gift also, though, in your will at the time of your death. You can gift at the end, a final distribution of any trust you create in your will. You can give in the event you and your entire family pass. I often suggest this for young families where it's like, okay, if you were in a tragic accident and the two of you and your child all passed, does anybody in your life really need that wealth? It is possible for you to gift it to them, of course, but do you want to gift it to an organization that matters to your family, the college where you guys met, the organization where you do your community service? You know, we can really be thoughtful about that. So that's a failure of line designation is what that means. And then I just like to hear about the charities my clients feel strongly about and be especially considering how to provide for them. Like I talked about earlier, sometimes gifting an IRA directly to a charity can make good sense. I talked on this a little bit, and I know we're getting close to the hour, but you want to be thinking about those 3 life stages, like I mentioned, young children, children about to launch, and retirement. It is also totally normal and fine, and happens to me all the time, that I have single clients who come in and say, I just never got it around to it. And here I am, 70 years old, and I don't have any kids, but I want to make an estate plan. And I say, well, I'm so glad you're here, right? There's, you want to do it regardless of the time. If you've missed the previous stages, it doesn't mean don't just kind of throw up your hands and don't do it. So stay in touch during those life stages. And I think that's a lot. Oh, if you are divorced, your family has major changes, are big times to update your estate plan. And we would talk about that when we met, things to be aware of. If your kids have a big thing that comes up for them or a health related issue, letting me know, and then we would update accordingly.
There's one thing I wanted to make sure to.
That's all I had prepared. So you go ahead with your questions there.
No, thank you.
Yeah.
This has been so informative. To
Good.
tie into what you were speaking about earlier about the power of attorneys and the financial power of attorney. It seems like there's more of my friends and people that I know whose parents are ailing from a form of dementia onset or
Mhm.
Alzheimer's. It's really important to understand to have those pieces in place because
Mhm.
I unfortunately have a friend who reached out to me because my mother had Alzheimer's. Thankfully, they had a power of attorney in place, but they didn't have one. Then suddenly his father just passed. So now, because it's being questioned, does she understand what she's doing?
Mhm.
The power of attorney is being challenged, and it's making everything much more difficult.
So
So,
difficult. Yeah.
if you highly encourage you to reach out to anyone in case they have elderly parents where, oh, they're getting forgetful. I thought that about my mom for a very long time. And oh, this is terrible. Um,
Mm.
you take it for granted. So oh, so sorry. This was not planned. So
It's
you just
totally
want to make
fine.
sure you get that in place. And if
Yeah.
you hear it, recommend it to others.
Mhm. Absolutely. Oh, it's so yeah, it hits you right in the heart because it's just something that you're so well served by long after you get that document in place. It's just going to be so helpful. So I know how hard that can be. And
Yep.
wondering, hey, is this the time to get more immediate active powers in place, et cetera? So yeah.
I know, Allie, to be respectful of your time, we ran up
Yeah.
right on the hour. So
Yeah.
there were some questions. I
Okay.
will have Allie I'll send those to her and get those answered. I'll make sure to include it in the follow-up for everyone. And definitely want to encourage you to reach out to Allie if you have any questions directly, because it's going through this process, you really need an advocate who you can trust. And it's very important decisions that are coming when you might not be in the right frame of mind, and it really helps your loved ones to have this in place. One question I wanted to ask, Ali, that I think is
Mhm.
helpful for myself. When I used to think about wills and trust, I was like, I don't have that much money. I don't have that much in assets. So
Mhm.
can you shed light on that? Like when is
Oh.
it recommended?
Oh, absolutely. So there is a way, if your estate, I don't actually know the exact dollar amount off the top of my head, but that you can do what's called such a small estate affidavit. So if you have an especially small estate, so I think it's like under 100,000 or 60,000 is the number. I have to look at the statute. I don't do it myself. I just tell folks, this is how you do it. So, anything above $100,000, I mean, you really need to be thinking about where would you want that to pass, to even that is such a significant amount of money. I believe that no gift is too small to make. And I have people who have small estates who still want to do a will because they want to make sure that there's oversight and that the gifts that they intend to make are very detailed in their will and are determined. And so there is not a person who has come into my office that I've said, oh, because of the size of your estate, you do not need a will. That's just simply not true. So
Gotcha. Well, we still have a few minutes left here. If you're
yeah,
muted and you have questions, the typed
I
ones in the chat will definitely get answered.
Yeah, I think
Anyone have
I
one?
hope I answered a couple of those. I see a couple at the bottom about tax neutral and about retirement assets. I think I mostly answered those, but yes, occasionally you can decide those should pass through the trust, but that's a decision. And then tax neutral, just meaning there's no real tax benefit to planning through a revocable living trust versus a will is what I meant by that. Did you have a question, Phyllis? Thanks for showing your camera. No, okay. Okay, nice to see you. And then let me see if there are any other. Community property has to do with all types of property. I think someone asked if that had to do with just real property. No, all nature of all property. And then
There was one on the IRA. Do retirement accounts go into a trust?
so retirement accounts are those that are non-probate and can pass directly, as a reminder, they can pass directly to the beneficiaries. So if you have your beneficiary designations up to date and those work for you, great. If you have minor children, we may want to consider having those pass through the trust to the minor children. They'll still receive it, but just that it would be the trust that's named potentially as the recipient. And so that then the trustee can manage those retirement accounts as well as part of their job in administering the trust.
Anyone else have questions?
Great. Well, I'm sure Keith will tell you how to reach me. I'm happy to be a resource for you. I'd happy to interview and see if we would be a good fit for being to working together in an attorney-client way. My entire firm, there are many of us that practice estate planning, and we welcome the chance to work with each of you and meet you at another time.
It's great. Thank you so
Okay.
much for joining us, Allie, and really
Yeah.
appreciate everyone for attending.
Yeah, my privilege. Thank you so much, Keith, for the invitation. Yeah, happy to do it.
All right. You all take care.
Okay. Thanks a lot.
Bye-bye.
Okay, everybody, enjoy your day.